Welcome to another episode of Go Ahead Ask podcast by the Exeter Group. Today on Go Ahead Ask, have you been told that you haven't held title to your property long enough to qualify for 1031 exchange treatment, or that the property you're selling and the property you want to buy is not considered like-kind property and you might not qualify for 1031 exchange treatment? We're going to unravel that today on Go Ahead Ask.
Building wealth in real estate? Let the Exeter Group take the mystery out of how it's done on Go Ahead Ask.
Welcome to the next episode of Go Ahead Ask podcast by the Exeter Group, where we unravel the mystery of investment real estate to help provide investors with better quality information so they can make better informed investment decisions. I'm Bill Exeter, Chief Executive Officer of Exeter 1031 Exchange Services, and your host today. The Exeter Group of Companies includes Exeter 1031 Exchange Services, which serves as a qualified intermediary. We administer all types of 1031 exchanges. We cover all 50 states. We're also one of the few that administers foreign property 1031 exchanges. The Exeter Group also includes Exeter Trust Company that serves as custodian for self-directed IRAs and individual 401k plans, as trustee for title holding trust or land trusts, as escrow agent for specialty holding escrows, and also providing just general custody services, all of which focus and specialize on the non-traditional assets or alternative asset industry. We encourage questions on Go Ahead Ask. So anytime you may have a question or a topic that you want us to cover, go ahead and contact us by emailing us at ask@exeterco.com, or you can call us at 619-239-3091. And if you love our podcast, please like it, subscribe to it, share it, and comment on it. We will always respond to any questions or comments that you might have. Today on Go Ahead Ask, we're unraveling the mystery of qualified use and like-kind property in terms of 1031 exchange transactions. Investors and their advisors often get hung up on the length of time that they have or that they haven't held title to their property. They often get hung up on the definition of like-kind property. What is like-kind? Based on what they've sold versus what they're acquiring. And there's lots of confusion out there regarding both of these issues. These are probably two, if not the two, most important issues involved when structuring a 1031 exchange transaction. So today we're going to unravel the mystery of what is qualified use and what is like-kind for 1031 exchange purposes. So let's dive right into that. First, the first couple of episodes that we had on Go Ahead Ask kind of talked about the basics for 1031 exchange purposes. So if you want to go back and kind of review the first, say, 3 or 4 episodes, we discuss all the basics. And we do touch upon qualified use and like-kind property. But this is an area where there's lots of confusion. So we wanted to spend a specific episode just on those two topics. Part of the confusion with both of these topics is that folks will call 3 or 4 or 5 different providers or experts, and they'll probably get 3 or 4 different answers, and they walk away completely confused. And the question is, well, what is the real requirement? What do I really have to do? Because I don't want to make a mistake. And the real issue here is there's a lot of gray area. There's a lot of flexibility in some of these issues. So you get a lot of opinions out there. They're not necessarily wrong. They're just opinions, and they come from different points of view. And they're probably all right, just different degrees of risk, perhaps, different degrees of being conservative versus aggressive. So we try to unravel those mysteries here and kind of let you know what the real issue is, and then you can decide really what's right for you. So that's what we're going to try to do, is unravel the mystery today on the qualified use and the like-kind topics. So let's focus first on the qualified use. Qualified use means that anything you're selling as relinquished property and anything that you're acquiring as replacement property in a 1031 exchange transaction must be held for some type of rental, investment, or business use. And that sounds pretty straightforward, but it really is not. There's a lot of confusion, a lot of gray area in there. So we're going to kind of unravel that and drill down into specific examples as to what is and what is not considered qualified use and why. So first, I mentioned that people get hung up on the length of time, and folks often will say, well, you didn't hold title to the property for at least 1 year, or at least 1 year and 1 day, or 2 years, so you don't qualify for 1031 exchange treatment. And that's where a lot of confusion comes into play. The tax code, the treasury regulations, and a lot of the rulings out there have absolutely no holding period required. So that's the first thing you need to know, is there's no specific holding period required in a 1031 exchange. But what the code and the regulations do make clear is that the taxpayer or investor must have the intent to hold the property for some type of rental, investment, or business use. So it doesn't specify a length of time, but it does specify that the critical issue is you have the intent to hold the property for rental, investment, or business use. So what it really boils down to is, if you get audited by the IRS or by a state audit agency, you need to be able to demonstrate that the property you sold as relinquished property and the property that you acquired as your replacement property that you had the intent to hold both of those for some type of rental, investment, or business use. So that's kind of why investors and advisors get hung up on the length of time that you've held title or haven't held title to a property, because the longer you actually hold a property as rental or as investment or as business use property, the easier it is to prove that you had the intent to hold it for that purpose. The shorter the timeline, the more difficult it is to prove. But that's not the end all. That doesn't mean that if you held it for a month, you won't qualify for a 1031 exchange. It just means it's going to be more difficult to prove that you did intend to hold it for investment purposes. So let's kind of drill down into the qualified use in a lot more detail. So number one, the overriding requirement is you must have the intent to sell relinquished property and acquire investment property, replacement property that's held for some type of rental activity. It could be renting under a rental agreement. It could be under a lease agreement, something you could rent it out or lease out vacant land to a farmer to produce crops or to raise livestock or something like that. Anything that you rent or lease or contract to produce rental income is a rental income or income producing property. It does not have to produce cash flow. It does not have to produce income, contrary to popular belief. You could, sell property that you were just holding for investment and then buy property that produces some type of income. For example, maybe you've owned a large plot of acreage, just dirt, vacant land, and you've had it for years and you've held it for investment purposes. And then you realize, you know what, today my land is not producing any cash flow. It's not producing any kind of income whatsoever. It's gone up in value. I have a capital gain or a profit today. So maybe I should sell that and reposition that into an asset that does produce income, that does have some type of cash flow. So the 1031 exchange would allow you to sell that land, do a 1031 exchange, defer your federal and state capital gain taxes, and reinvest in something that does produce cash flow. So that's a perfect example of what the 1031 exchange can do for you. And you've gone from a non-cash flow, non-income producing property or non-performing property, if you will, into an asset that does produce cash flow. So you've kind of gone from an investment property that's held for capital appreciation into a property that now you're holding for rental or income production. In either of those situations, you could also either sell or acquire property that you're going to use in some type of a trade or a business operation, and that would also satisfy the qualified use requirement. So let's drill down with some tax cases or tax court rulings to give examples there. So a lot of folks are under the impression that if you held the property for a very long time, you would qualify for 1031 exchange treatment. And that's not necessarily the case. And on the flip side, they think that if you held it for a very short term, let's say a month or 2 months, that you won't qualify for a 1031 exchange. So let's use some specific examples. There's two tax court cases where two individuals were developers. These are completely unrelated cases. Both individuals bought dirt. Both intended to develop and build out single-family homes. Both intend to sell, just like developers do. You buy, you build, and you sell the results. In these cases, neither one of these developers built or developed anything. They both bought dirt and they both just held it. One held the dirt for 12 years, long-term hold. The other one held even longer for 20 years. Both ended up deciding not to develop the property. They did not build anything on the dirt. They both ended up selling. So one sold at the 12-year mark, one sold at the 20-year mark. In both cases, they did 1031 exchange transactions. In both cases, they were audited, and in both cases, their 1031 exchange was disqualified. It shocked a lot of people because this is a 12 and a 20-year holding period. So clearly they held it for investment, right? Well, unfortunately, no. In the 1031 exchange world, we look at intent. And in this case, the intent was to buy, build, and sell. So their intention was to buy and build it, just like inventory in a business. This is inventory in a real estate development business, and then sell it. So the property was not held for investment. It was actually held for sale, like inventory. And any property that's held for sale will not qualify for 1031 exchange treatment. So some other examples of that: if you're in the business of buying real estate and then you rehab it or you fix it up and then sell it, people nickname them flippers, rehabbers, etc. The same thing. You're really buying, you're rehabbing, and you're selling. So you're holding the property for sale. You're not holding the property for investment purposes. So you don't qualify for 1031 exchange treatment. If you are a condo conversion specialist, so you buy an apartment complex, you convert to condos, and then you sell, the same issue applies. You're really buying, converting, and selling. So you're holding these assets for sale as opposed to held for investment purposes. So that also does not qualify for 1031 exchange treatment. Now, in all of those examples, if you were to buy the property and then you built or developed, or you rehabbed or fixed up, or you converted to condos, and then you held as rental property, so you didn't sell, you were actually intending to buy, do something to the property, and then hold it, then you would qualify for a future 1031 exchange transaction because you actually bought with the intent to hold for rental, investment, or business use. So that kind of helps give a kind of a clearer understanding that it really boils down to, do you intend to buy and hold, or do you intend to buy and hold for sale? I should say the first one was buy and hold for investment purposes. Now, on the flip side, we had one of our clients who did a 1031 exchange, bought a condo as the replacement property, did not read the CC&Rs until after the close of the purchase transaction. Within a few days afterwards, happened to read the CC&Rs and find out you were not permitted, or he was not permitted, to rent the property. It had to be owner occupied. So, of course, if it's owner occupied, that's personal use. That does not qualify for 1031 exchange treatment. It has to be rental, investment, or business use. So, of course, he panicked and exchanged a lot of emails with his advisors, including us. What he ended up doing is selling the property and doing another 1031 exchange and reinvesting in another condo that he could rent out. As luck would have it, he was actually audited by the California Franchise Tax Board. He only held title to that new replacement property in the first 1031 exchange for about a month and a half. But the California Franchise Tax Board allowed that 1031 exchange to proceed or to qualify because he could show his intent was to hold for investment, in this case rental purposes, but there was a business reason why he couldn't do that. So there's all sorts of reasons that might help define or explain why there's a short-term hold. In the last couple of years, we have had all sorts of COVID-related issues. Whether it be the COVID disease itself, whether it be eviction moratoriums, etc. So there was all sorts of reasons where folks had just bought a property through a 1031 exchange and then decided it was time to sell and reposition. So there's also folks that had financial distress during COVID, or even during the, let's say, the 2008 recession, where they had just acquired a rental property and then had to convert it to their primary residence. If you can argue and show your intent was to acquire and hold for rental, investment, or business use, but there was a business reason, an economic reason, a medical reason, or something like that where you had to change your intent, you had to change the plans, then you will still have a valid 1031 exchange. So it all boils down to intent and what you can prove should you get audited. So that's really the real issue on qualified use. So really, to sum that up, that's why folks get hung up on the length of time you've held title or didn't hold title to the property. If you held title to the property for, let's say, a year, that's a plain vanilla 1031 exchange. It should probably qualify for 1031 exchange purposes. But if you're going to do something that's a little outside the box, you're pushing the envelope, perhaps you want to convert it to a primary residence down the road, 1 year may not be enough. It's only 1 year. It straddles 2 tax returns. Should be enough to prove that that was your intent, but what if it's not? Because it really boils down to your intent. Under audit, if they can show your initial intent was to use it for personal reasons, personal use, it could disqualify the transaction. So we want to make sure we can justify and prove that your intent was to hold for rental, investment, or business use. So in that case, maybe a 2-year holding period, which will straddle 3 tax returns, would be a better defense and argument that you did in fact intend to acquire and hold for rental purposes. So again, the longer you hold it for rental purposes, the better and the safer the overall argument is. And we're going to take a quick break for a message from our sponsor. This episode is sponsored by our sister company, Exeter Trust Company. Did you know that all individual retirement accounts are self-directed IRAs? It's because you choose where to put them. You choose whether to put your self-directed IRA at a bank or at a securities or brokerage firm or a life insurance company. So that makes it self-directed. But did you also know that all IRA custodians are not created equal? Most IRA custodians, like the banks, the securities firms, and the life insurance companies, limit you to publicly traded investments such as stocks and bonds and mutual funds. But some IRA custodians, like Exeter Trust Company, allow investors to invest their IRA funds in other alternative assets such as real estate. Investors can acquire real estate, mortgages, deeds of trust, or tax lien certificates inside the IRA as an investment inside the IRA. To learn more, call Exeter Trust Company at area code 307-222-8750 or visit them on the internet at exetertrustcompany.net. And we're back with Go Ahead Ask, and we're talking about the definition of qualified use and like-kind property requirements in a 1031 exchange. And we just got finished kind of going through the qualified use requirements, what does qualify, what does not, and it really boils down to intent. So anytime somebody says you don't qualify for a 1031 exchange because it's not qualified use, or because it's not like-kind property, or because the length of time that you held the property or didn't hold the property just doesn't qualify. That's not necessarily true. We have to look at the asset itself and ask the question, what's the intent? What was the real intent here? What can we argue and demonstrate the intent was should you be audited? One of the easiest ways that we just got finished talking about too, to demonstrate intent is to hold the property for as long as you can to justify that it was held for rental, investment, or business use purposes. The shorter the holding period, the more difficult it is. And with that, let's transition into the second topic, which is like-kind property. There's also lots of misinformation out there. There's still curriculum out there where some groups will talk about like-kind that means condo for condo, meaning if you sell a condo, you have to reinvest in a new condo. If you sell apartments, you have to reinvest in new apartments. That is absolutely not true. Those are folks who don't really understand the 1031 exchange. They don't really understand the definition of like-kind property. So to boil it down, literally like-kind means that you're selling real estate, you have to buy real estate. Simple as that. So we just look at what did you sell and was it considered to be real estate? What did you buy and through the 1031 exchange, and is it considered to be real estate? And if they're both real estate, you satisfy the like-kind requirement. So literally any kind of real estate is considered like-kind to other real estate. The one area where I want to clarify that is it does require that it be U.S. property, so United States property for other United States property, or what we call domestic for domestic. You can, contrary to popular belief, you actually can do a 1031 exchange on foreign property. Years and years ago, you used to be able to do exchanges between U.S. and foreign property and vice versa. Now you cannot. So the 1031 exchange must be foreign property exchanged for other foreign property in order to qualify for a like-kind exchange treatment. So that's really the only restriction, if you will, inside that like-kind definition, is it has to be U.S. for U.S. property, meaning domestic for domestic, or foreign property for other foreign property, or non-domestic for non-domestic property. So long as that is met, then you'll be okay. Interestingly, domestic property includes all 50 states in the United States. It also includes things you wouldn't think of course, Washington, D.C. It includes Guam, the Marianas Islands, and the U.S. Virgin Islands. So those are also considered to be U.S. territories and are considered a like-kind property. Also, interestingly, is Puerto Rico does not fall into that category. It's a different classification as a territory, so it doesn't fall into the like-kind definition. So that gives you kind of an idea of the like-kind property, but let's drill down a little deeper on like-kind and really expand upon that. So like-kind can mean a lot of different things that you wouldn't even consider to be like-kind property. So most people look at real estate and they think of single-family homes, multifamily or apartment complexes, commercial office, commercial retail, commercial industrial properties, retail shopping centers, things like that. But there's a lot of other assets that are considered to be real estate and would qualify for 1031 exchange treatment. Things like air rights, water rights, mineral rights, certain types of oil and gas interests are also considered to be real estate under various state laws. So that would also be considered like-kind property for a 1031 exchange transaction. So you could sell a single family rental and exchange into various types of mineral rights, oil and gas, etc. And that would qualify as like-kind property. Also, fractional ownership or percentage interest in a real estate would also qualify. So you could sell a single family property and exchange into some type of a fractional ownership position. Before 2008, it was very popular to exchange into a syndicated tenant in common investment property, or TICS. After 2008, the Delaware Statutory Trust has really kind of taken off and is more because it's lender driven. So you can exchange out of that single family home and you can buy a percentage interest in a Delaware statutory trust. So you end up buying a very small fractional or percentage interest in a very large asset, and that qualifies as like-kind property for 1031 exchange treatment. So lots of ways to diversify or change your portfolio into other types of real estate that might accomplish your goals and objectives better. So like-kind does not mean condo for condo. Like-kind simply means real estate for real estate. And the only subcategory there is it has to be domestic for domestic, or U.S. for U.S., or it can be foreign property exchanged for other foreign property. Probably just as important is to talk about what is non-like-kind property. So typically anything that has personal use involved is not going to qualify as like-kind property. So your primary residence, your second home that you use occasionally, a vacation property that's used for personal use, those are not going to qualify for 1031 exchange treatment because it's not held for rental, investment, or business use. It doesn't satisfy the qualified use requirement. It's used for personal use. They fall under different parts of the tax code. So like your primary residence falls under section 121, or what we call the 121 exclusion. If you've lived in it for 2 out of the last 5 years, you can sell that and you get $250,000 in gain tax-free if you're single, $500,000 tax-free if you're married. Second homes, vacation homes don't really have any special tax advantages. But keep in mind, just like we talked about in the beginning under qualified use, it's all about your intent. So if you've had a second home or a vacation home for years or decades and it's just held for personal use as a family, you could always stop the personal use completely You can convert it to rental, investment, or business use property. That's an example of something where you probably want to rent it longer, maybe 2 years to straddle 3 tax returns, maybe 3 years to straddle 4 tax returns, to show that you really did intend to convert it to rental or investment use. And then at that point, you would qualify for 1031 exchange treatment. So there are all sorts of ways that you can combine this. You can alter your intent, change the usage, and then qualify for 1031 exchange treatment, or partner something like a 121 exclusion and a 1031 exchange. There are ways to do that as well. So just because today it's not like-kind doesn't mean it won't be like-kind in the future if you change the use, or it may or may not be qualified use in the future, depending on your usage. Let's get into more specifics where it gets a little more complicated. So like-kind property can be complicated based on the entity that owns the property. Probably the most common is some type of a partnership. So if you buy real estate inside, let's say a limited liability company or LLC, and you have multiple members in that LLC, it's treated generally as a partnership for tax purposes. So in that case, you have to remember that you as an individual do not own real estate. You own a membership interest in the LLC, which is treated as a partnership interest. Or if it's a general partnership or a limited partnership, that you own a partnership interest in the partnership. You don't own real estate, you own a partnership interest, and the partnership as an entity actually owns the real estate. So when the partnership decides to sell the real estate, the partnership is selling real estate, not the individuals. So that's not going to qualify for 1031 exchange treatment if all the individual partners want to go different directions, they want to get their cash, and they each want to do their own separate 1031 exchange transaction, because again, they don't own real estate, they're not selling real estate, all they're getting is a cash distribution from the partnership. It is possible to alter that depending on the facts and circumstances in the timeline. So the safest way is the partnership stays together, they sell together, they do a 1031 exchange together, and they reinvest together as a partnership. There's absolutely no risk with that because the partnership itself is the taxpayer, the owner, and it does the exchange. In many cases, when it's time to sell the real estate, the partners want to go different directions. That's where it gets complicated. We have to look at all the partners, what are their goals and objectives, and there's probably some type of solution if we have enough time to plan around it. But again, it all boils down to intent. So we have to remember that you don't own the real estate, the partnership does. It gets a lot more complicated, so we don't have time to get into details here, but I wanted to leave that with you, just so if you own title to real estate in some type of an entity, remember, you don't own the real estate, the entity owns the real estate. Now, there are some exceptions to that. Exceptions would be any type of entity that is a disregarded entity and really is treated as if you, as the underlying owner of the entity, really owns the real estate. Some examples of that would be your living trust. It's a family trust or living trust. You and or your wife would be the trustors and owners of the trust. It's a disregarded entity. Everything gets passed through and reported on your individual tax returns. The entity itself is ignored for tax purposes, and it's treated as if you and or your wife are the owners of that property. A single member LLC could be a disqualified entity. So if a single member LLC is owned by one person and you treat it, set it up, and report it as a single member LLC and a disregarded entity, that's ignored for tax purposes. It's treated as if you own the property directly. In a community property state, a husband and a wife are considered to be a single member, and it's still a disregarded entity. So that would certainly work as an exception. Delaware statutory trust and land trusts are also pass-through entities and disregarded entities. So what does that mean? That means that if you as individuals, let's say you own property inside of a LLC, it's a husband and wife, you're in a community property state, that's considered to be a single member LLC and a disregarded entity unless you've elected otherwise. So when you sell that asset out of the LLC and you go to buy your replacement property and the lender says we will not finance in the LLC, because the LLC was a disregarded entity, you're still allowed to buy as individuals, and that will still qualify because that LLC is a disregarded entity. So I probably went a little deeper there than I intended to, but that kind of gives you an idea of how qualified use of like kind can be affected, because it all boils down to intent and it boils down to the taxpayer. So that gives kind of a general idea of the qualified use and the like-kind issues that are involved in 1031 exchanges. Just keep in mind that like-kind means real estate for real estate. Qualified use means intent to hold for rental, investment, or business use, not intent to hold for some type of sale. And then you'll be okay. And as always, we're always available to brainstorm should you have questions regarding those two issues. But those are probably the most important two issues in structuring the 1031 exchange, in making sure that the assets you're selling and the assets you're buying are going to qualify for tax-deferred exchange treatment as part of a 1031 exchange transaction. So that's kind of a wrap for today. So thank you so much for listening to Go Ahead Ask by the Exeter Group. Kind of a quick follow-up is last episode we talked about choosing a safe and sound qualified intermediary. So you might want to go back and take a look at that. Qualified intermediaries are not created equal. You'll be surprised to know that very few qualified intermediaries actually have any type of regulatory or government oversight. And we spent a number of years going through the regulatory review and approval process so that we are licensed, regulated, and audited by the Wyoming Division of Banking. So all the funds are held with Exeter Trust Company as a licensed trust company. The next episode is kind of pending. We are told that the House Ways and Means Committee in the House of Representatives is looking to pass the legislation that could affect 1031 exchanges and or affect self-directed IRAs this coming Thursday. And then they're going to send it right to the Senate for a vote on the Senate floor. So our next podcast might be right after that. And so we're going to keep that kind of slot open. We hope that we'll have a final idea of what's going to be or what is included in that bill. We can bring that to you here on Go Ahead Ask. Otherwise, we'll come up with a different topic if they still haven't decided that. We have had a couple of episodes in the recent past discussing the risks to 1031 exchanges that the Biden administration has proposed. Those were not and have not been included in the bill at this point. So the 1031 exchange at this point is safe, but there are all sorts of really horrible inclusions in the bill that address self-directed IRAs and alternative assets. And we've been working hard to educate members of Congress as to why that is a horrible idea. So stay tuned for more information on the proposed changes that are included in that legislative initiative. As always, go ahead and ask if you have questions, if you have topics you'd like to have us address, send us an email at ask@exeterco.com or give us a call at 619-239-3091. Or even if you have an expertise that you'd like to share with others and you'd like to appear on Go Ahead Ask, reach out to us. If you love our podcast, please like it, share it, subscribe to it, and comment on it. We will respond to all the comments on there. Again, thank you so much for joining us today. We look forward to talking to you next time. Thanks again. Take care. Bye-bye.
Thank you for listening to Go Ahead Ask with the Exeter Group. Join us for our next episode when we further unravel the mysteries of real estate.